Hello and welcome to Live Law Explains, a series for you to make sense of complex legal concepts, cases, and issues without the confusing legal talk. I am Padmakshi Sharma, your host for the video, and today I will be decoding the electoral bond scheme case in which the Supreme Court of India recently reserved its judgment. We will talk about it all, the arguments which were raised by the petitioners, the arguments which were raised by the respondents of the union, and the queries which were raised by the bench. But before we do that, we must understand what the electoral bond scheme is. And in order to do that, we must know what an electoral bond is. Well, an electoral bond is a bearer bond, one which can be used by individuals and corporations which are incorporated in India to make donations to political parties. These bonds can be purchased in denominations ranging from 1,000 rupees to a crore from the State Bank of India or the SBI using a KYC compliant bank account. Essentially, you go to the SBI, transfer money from your KYC compliant bank account and get an electoral bond which you can then donate to a political party with at least 1% total vote share. The political party can then encash this bond within 15 days. Now, why would you donate via electoral bonds instead of using other means to donate to parties such as checks or demand drafts or even bank transfers? Well, because the identity of the donor is anonymous when they donate through electoral bonds. It is only known to the SBI and the law investigation agencies if they press an investigation who the donor really is. So now to introduce electoral bond scheme, amendments were made to 4 key legislations. Representation of the People Act 1951, Income Tax Act 1961, the Foreign Contribution Regulation Act or the FCRA 2010 and the Companies Act 2013. Let's have a look at all these amendments one by one. In 2017, the Finance Act amended Section 29C of the Representation of the People Act. So earlier, if a company or an individual donated to a political party and that donation or contribution was 20,000 rupees or more, then the party had to publish it in a contribution report. So if anyone contributed less than 20,000 rupees, then the donation or the contribution could be anonymous. But if the contribution was more than 2,000 rupees, then a report had to be published, effectively meaning that the donation would no longer be anonymous. The amendment stated that if someone is donating through an electoral bond, there would be no obligation to disclose the contributions received, no matter how much money was donated. Further, the anonymous cash donations to political parties, which were earlier capped at 20,000 rupees, were now capped at 2,000 rupees post the amendment. Then Section 11 of the Finance Act of 2017 amended Section 13A of the Income Tax Act, which again exempted political parties from their obligation to keep a detailed record of contributions received by means of electoral bonds. These two amendments made the donations through the electoral bonds anonymous at the end of the political party, meaning if the political party received donations through electoral bonds, it only had to disclose the amount that it had received by means of the electoral bonds. And it no longer had to disclose who donated that amount to them or where they were getting their funding from. Now let's see the other 2 legislations which were also amended. Section 154 of the Finance Act amended Section 182 of the Companies Act, effectively removing the upper limit of corporate donations to the political parties. Previously, companies could only donate up to 7.5% of their net profits over the previous 3 financial years to a political party. This meant that the company had to mandatorily exist for at least 3 years and it had to be a profit-making company. After the amendment, the 7.5% limit was removed. So now even if a company which only had existed for a year and was not running in profit could donate. Finally, the Finance Act amended Section 2 Clause 1 Clause J Clause 6 of the FCRA. In doing so, this amendment redefines the concept of foreign source. Prior to this amendment, foreign companies were strictly prohibited from contributing to political parties under both the FCRA and the Foreign Exchange Management Act, or FEMA. But now, after the amendment, foreign companies could donate to Indian political parties, not directly, still not directly, but through subsidiaries which were registered in India. Again, even companies do not have to disclose who they donated to. They only have to now disclose how much they have donated as electoral bonds. So this is the electoral bond scheme. Against this scheme, petitions were filed by political party CPIM and NGOs Common Cause and Association for Democratic Reforms, that is ADR. There were two main issues argued before the court in the matter. First was the right to information of citizens versus the right to privacy of a donor. The petitioners argued that on a larger scale, citizens had a right to know which party was getting funded by who under Article 19, Clause 1, Clause A of the Indian Constitution. Citizens had a right to know who was funding the party that they were voting for. So this legally ordained informational black hole went against the concept of an informed electorate. On a smaller scale, it was asserted that the scheme also violated the right of information of shareholders of a company, because any company which wanted to donate to a political party did not need to tell even its shareholders who it was donating to. It only needed to inform how much it was donating to that particular political party. So the petitioners questioned the lack of consultation or consent which was taken from the shareholders for their funds being used for political contributions. The union, on the other hand, argued that the donations made through the bonds had to be confidential, as the donors had a right to informational privacy. This privacy, this confidentiality, would protect the donor from victimization and retribution that they may face from a political party if their affiliation with another opposing party was made public. Let us take an example. I donated to party A, but party B came into power. The union's argument was that if my donation was not anonymous, then party B would know that I did not donate to them, and that may harm me. Thus, the right to know and the right to informational privacy had to be balanced. The union submitted that while the public had a right to know, it should be limited to cases of genuine public interest, and curious or prying inquiries should not be allowed to infringe upon an individual's right of privacy. The union argued that in this case, there was no genuine public interest in knowing that who was funding which political party. It was a mere curiosity, because the voters did not make decisions solely based on campaign contributions from specific individuals or organizations. Instead, the voters based their decisions on factors such as ideology or principles, leadership, and the efficiency of a political party. To this argument, the petitioner submitted that the scheme would not prevent victimization in any manner because the donor's identity under the scheme was not really confidential. The petitioners argued that the State Bank of India, which was under the union, already knew what the donor's details were. Similarly, law enforcement agencies, which were again under the union, while investigating, could also know the details of the donors. So, while the government of India, and by that extension the ruling party, knew where the donations were coming from and which party they were essentially going to, the citizens and the opposition parties were kept in dark about the same. The petitioners also argued that the right to privacy could only be guaranteed to natural persons and not corporations. On a similar note, the bench also orally remarked that the electoral bond scheme was not really anonymous or confidential for that matter, and it only ensured selective confidentiality. CJI D.Y. Chandrachud stated that there were always other ways to get information, because while a company, it did not need to disclose who it donated to, it was bound to disclose the amount that it had donated as electoral bonds. And that was also present in the company's balance sheets. Similarly, while a political party again did not need to disclose who donated to it, but it had to disclose the amount that was received to it through electoral bonds. So by mix and match, a party eventually could know who donated what to which party. The second set of arguments was based on whether the scheme promoted corruption or not. The petitioners argued that the electoral bond scheme, instead of reducing the cases of corruption, was actually promoting it. First, it was argued that any company could donate to a party for quid pro quo and no one would know about it. For instance, a company could donate hundreds of crores to a political party seeking to get, let's say, a government contract. But since the information about who donated to who was not public, the citizens would not be able to question it. Additionally, due to the amendment to the Companies Act, even loss-making companies or those with no substantial business activities, essentially shell companies, could also make unlimited donations to political parties. The petitioners also stated that due to the amendment to the FCRA, foreign entities could now purchase the bonds through subsidiaries which were established in India. So, a foreign company could open a subsidiary in India as a shell company, meaning that the company would not really be a profit-making entity. The company would not really participate in any business, but it would simply be a shell which would get money from a foreign source and funnel all of that money to a political party. This would allow foreign sources to fund Indian political parties, and essentially it would also promote corruption. The petitioners highlighted that in absence of any information provided to citizens, they could never question political parties for corrupt practices because they could not, they did not have any data. They could get sued for defamation. They could never prove that a particular party was in fact practicing corruption. On similar lines, the bench questioned the union if the scheme was legalizing kickbacks, which are illegal payments that are intended as compensation for favorable treatment from any political party. The union disagreed with this. The union stated that if this scheme did not exist, the donors would simply pay in cash. That would also be anonymous. Cash donations are also anonymous. To this, the bench stated that it was not asking the union to go back to cash-only payments. Instead, it was telling the union that there could be a better scheme, which could be more proportional. The scheme could be more transparent. Responding to this, the union argued that there were enough safeguards in the scheme to prevent corruption from happening. For instance, there was a requirement for both donors and political parties to have designated accounts and branches from which they could purchase or encash electoral bonds. Then there was 1% vote threshold for political party eligibility. So fake parties, which were formed solely for the purpose of claiming exemptions, they would not get donations by electoral bonds. Further, the union explained that there were KYC or Know Your Customer requirements, which included providing for Aadhaar card numbers and also addresses to purchase these electoral bonds. Additionally, the bonds had a validity of only 15 days from issuance. This 15-day limit, as per the union, would also reduce the potential for quid pro quo situations or quid pro quo deals, as parties were required to encash the bonds only within this 15-period limit. However, the Chief Justice underlined that before the scheme was introduced, companies could only donate 7.5% of their net profit of last 3 financial years. But now, any company, regardless of its profit or loss situation, could contribute. the CJI questioned the rationale behind allowing a company to donate its entire profit, whether it was 1 rupee or 100 rupees, without any proportional limit. He stated that a company was made to do business, not to donate to political parties. So why should it be allowed to donate 100% of its profit? The union explained that past experiences had revealed that some companies wish to donate more than the 7.5% limit allowed. This led them to create shell companies to circumvent the cap or just paying in cash. To address this issue and discourage the formation of shell companies or paying by cash for political donations, the government chose to eliminate the cap entirely. Another inquiry raised by the bench was about transferability of the bonds. The bench stated that since these bonds were bearer bonds, they were entirely transferable. So once an individual or an entity purchased a bond, they could simply hand it over to another person who could then donate it to the party. The CJI stated that any person could become an aggregator of electoral bonds, which means that he could purchase multiple of these bonds and then sell it to other people or hand it over to other people. So eventually, the person purchasing the bond who had provided with his KYC requirements may not even be the donor. The union argued that even if there was some potential for misuse, that was not a ground to strike down the scheme as illegal, because no system could be completely foolproof. So even if the union failed to prevent corruption through the scheme, that would not mean that the scheme was illegal per se. After 3 days of arguments, the Supreme Court reserved its judgment in this matter. It would be really interesting to see what the Supreme Court of India decides to give primacy to: the voter's right to know or the donor's right of privacy. What do you think the outcome would be? Comment below your views and subscribe to Live Law for more such content.